Hello, everybody, and welcome to this Landlord Law training webinar, where I'm delighted to welcome Brooke Lyne, who is a housing barrister, and she is going to explain to us how to read leases. Welcome, Brooke.
Thank you very much, Tessa. I'm really glad to be here, and thank you everybody for joining this morning. I was saying to Tessa before we started that I'm going to try very, very hard to make what is fundamentally quite a dry topic into a slightly more interesting one. And I think it is, and Tessa and I have discussed this, it's a really useful topic. And those of you that I know you're all landlords and you will be very used to reading AST agreements. But long residential leases can be a lot more complicated and tricky, and it's really, really important for you to get to know what your lease says, what it allows you to do. So hopefully, by the end of this session, you'll have a better idea of what your lease says, and the next time you need to read it for whatever reason, hopefully you'll find that task a little bit more straightforward.
Yeah, I mean, just to say, this is long leases rather than tenancy agreements. So if you are renting out your leasehold flat, this is going to be a really important talk for you. If you have any questions during the presentation, please put them in the chat box, and I will put them to Brooke at a suitable moment. So take it away, Brooke.
Thank you very much. Okay, so what we're going to cover this morning, and I'm expecting to take about an hour, but as usual, as most barristers, I suspect I'll go over that, but I'll try not to. The things that I want to go through today is a quick introduction to the types and formats of long residential leases. I'm then going to take you through the building blocks of an average long lease. So I'm going to talk through the key kind of structure of a lease and what you can expect to find in different parts of a lease. Then we're going to go through some general principles of interpretation in the hope that I can give you kind of an outline of what you should be thinking when you're looking at a long lease, and how you can understand the words used and the format. If there's ever a discrepancy or something you're not quite sure of, hopefully those principles can assist. Then I'm going to talk about a couple of specific problems of interpretation. And then we're going to look at some more specific points about service charge machinery, which is something I'm sure will be of great interest to many of you, especially when you get your annual service charge bills. It will be interesting for you to be able to look at those and perhaps be in a better position to challenge them or understand at least precisely what it is you're being charged for and if you're being charged correctly.
Maybe also if there's something that's specifically different to tenancy agreements, that might be a useful.
Yeah, I mean, as we go along, perhaps as and when I will try to point out where things might be different, because as you say, Tessa, there are some key differences, and also, it's important to remember from the outset, a tenancy agreement, short AST, is a form of lease. It's just a shorter form, and it doesn't have to be made by deed, but they are essentially performing the same function. They're granting someone a tenancy. Right. Types of long residential lease then. A bipartite lease is the most common one you'll encounter. And as the bi part indicates, it's a two-part lease with two parties, usually just the landlord and the tenant, straightforward situation. That's usually what you will find your situation is with your landlord if you own a flat. You might also find that you have a tripartite lease, which is where there are three parties. Normally, you'll find it will be the landlord, you as the tenant, and then a management company. And the key thing to point out here, and this is why it's different from a bipartite lease where you have got a management company instructed to manage the building, but they're not actually a party to the lease. In a tripartite lease, the management company has its own rights and obligations under the lease, despite not having a reversionary interest. So it's to be distinguished from a scenario where a management company has simply been appointed by the landlord to act as their agent when it comes to managing the block. So that can be quite important, because if you're writing to a management company that is a party to your lease, they may well have specific obligations and duties of their own. Whereas if you're writing to a management company that is simply the agent of your landlord, the scenario is slightly different. It also can be an important factor if you're, for example, thinking about bringing tribunal proceedings. If you only have a bipartite lease, you would only ever be bringing them against your landlord. If it were a tripartite lease, it could be, if the relevant person who has obligations under your lease is in fact the management company, it might be that you were bringing proceedings against them rather than the landlord. So it can be an important distinction. And the last form of lease that's on the slide, but we're not going to talk about very much today, is a shared ownership lease. So a similar situation, you'll find that a shared ownership lease will be very similar, but will usually include a staircasing provisions explaining precisely how you have your share, and often if you are to increase your share of your leasehold interest, the lease may set out the way to do that. Great. So format of long leases then, and it might sound like a strange thing for me to raise, but it is important because often I find I'm instructed to look at a matter for a leaseholder, and they send me what they think is their lease, but actually they haven't realised that their lease has been amended at some point over the years, and actually their lease is made up of several documents rather than one. So most commonly you'll find it's just one written document executed as a deed, and that's it. And you can normally, if you don't have a copy to hand, you can normally download a copy, assuming your leasehold is registered at the land registry. It usually will be. You should be able to download a copy from the land registry, because you'll have to pay for it a small sum, but they're publicly accessible, but you have to pay a fee. But it's possible that you could have more than one document. So you could have a deed, so a lease deed, by reference to another document. So, for example, a lease book that's common to all of the leaseholders in the block, and that the lease book isn't signed or witnessed, but it's the document that is incorporated into the lease deed that you've got. You might also find that there's a counterpart to your lease. So, for example, the best obvious example where this comes up a lot is where there's been a lease extension. So if you have enfranchised by getting an extended lease, you will often find that the lease extension is just a deed that is made by reference to your old lease. So when you look at the lease, actually what you need to look at is the deed the lease extension deed, and then also the old lease that it may well have been drafted by reference to. And you can find sometimes that it may be that small amendments were made when a lease extension were granted. So perhaps, if there was some discrepancy about the extent of the demise, so the extent of the area that you owned as leaseholder, you might decide when you're having a lease extension that you want to clarify that. So it might be that the lease deed actually clarifies a definition, for example, in the main lease. So you need to read the two documents together. So do check that. Make sure that you are looking at the whole lease and not just one part of it that may well have been varied by reference to another document. Great. Let's move on then to the building blocks for lease. And you'll see I've put inserts or some excerpts on the slides, and these are from real leases that I've encountered at various points in my practice. So we are looking at real leases. Some of them are quite old. I've taken excerpts from more modern leases, and I want to sort of at least give you a feel for what the words and what the page normally does look like. So often you will find, and certainly you will find in old leases, recitals or preambles. So the section that you can see on the slide here where it says, whereas the landlord is and the landlord has, those are not parts of the substantive lease itself. They are recitals to set the scene, essentially. And they can be really useful because if there is within the main part of the lease some kind of discrepancy or some kind of something that's not terribly clear, those recitals can be a really useful indication, essentially, when it comes to construing that lease, because those recitals essentially provide you with relevant context at the time when the lease was executed. And when we get on to principles of interpretation later, you'll realise that actually you're interpreting the lease as at the date it was granted. So if you were ever looking at the surrounding context, it's only by reference to what was happening at the time when it was granted, not by reference to the current context. So those recitals can be quite useful.